The senator from Connecticut.
Thank you, Mr. President. I'm here with a number of colleagues on probably one of the most important decisions we're going to make with respect to the future of justice in America. The nomination of Emil Bove to be a judge on the Court of Appeals for the Third Circuit, the second highest panel in our judiciary. And he is about as unfit and unqualified as any judicial nominee to come before this body in my 15 years here. And I say that with sadness as well as anger, as someone who still proudly would call myself a litigator, a trial lawyer, and a member of the Judiciary Committee, where I'm proud to serve with my great colleague, the ranking member now, Senator Durbin, and others from that committee will come before us tonight. We're here not only on the merits of Mr. Bove, but also because we were denied an opportunity in the committee to present fairly and fully our case against Mr. Bove based on the record. And we were denied an opportunity to elicit from the Department of Justice and the administration the facts that are necessary to evaluate his nomination. We were denied the opportunity to have a whistleblower come before the committee, a whistleblower who bravely came forward with facts showing how Mr. Bove suggested, indeed urged, that lawful court orders be disobeyed, that the Department of Justice ought to tell the courts to F themselves. We were denied access to an Office of Professional Responsibility investigation bearing on this nomination, an OPR inquiry into the failure of the team supervised by Mr. Bove to divulge to the defense exculpatory evidence, as they were obligated to do during a prosecution when he was an assistant United States attorney. And Mr. Bove himself, in the hearing that we conducted, was evasive, obfuscating. He refused point blank to answer relevant questions. One of my colleagues, Senator Whitehouse, who will be here tonight, characterized it as the deliberative process privilege. There is no deliberative process privilege. And Mr. Bove had no right to refuse to answer our question about what he has done in his role during the first 6 months of this administration. The fact is, he has been involved in a pattern of lawlessness and recklessness, a violation of individual rights and liberties, a pattern of corruption, unprecedented in the history of the United States Department of Justice, and he has been integral to it, participating actively in it. We have opposed other nominees because we disagree with their judicial philosophy. We've opposed them because they were out of the mainstream. They were ideologues with an axe to grind that was potentially detrimental to rights and liberties. Mr. Bove is in a different category. Yes, he is conservative. He's out of the mainstream. But he is corrupt. He's dangerous, vindictive, and revengeful in a way that this administration has made a pattern of doing. So I'm here to urge my colleagues to stand with us and oppose this nomination. I know that the strong dynamic, we've seen it again and again and again, no matter how many doubts my colleagues may have, to toe the line in thrall of President Trump or in fear of him. But the record here speaks powerfully, or it should, to our conscience and conviction. This nominee epitomizes the Trump demand for loyalty and fealty above all else to him, a sense that he has the power to do what no ordinary American can expect from judges or from prosecutors, that they will, in fact, rig the system in his favor, as Mr. Bove has done while representing, supposedly, the Department of Justice, because he was, like Pam Bondi and others who have taken senior positions, a lawyer, in fact, for President Trump, his personal lawyer, defending him against claims in his personal capacity before he took this role in the Department of Justice. A lot has been made of Mr. Bove's role in dismissing the case against Eric Adams, the mayor of New York. I'm not going to go through all the details except to say that Danielle Sassoon refused to make the argument in favor of dismissing those charges in exchange for concessions on immigration policy. She said it was an, quote, an improper offer of immigration enforcement assistance in exchange for a dismissal. The lead prosecutor on the Adams case resigned rather than take Mr. Bove's order, and he too said that it would be a violation of conscience and conviction, and that anyone who is enough of a fool, and I'm quoting, or enough of a coward to file your motion, end quote, should not do so. The judge in the case said, quote, everything here smacks of a bargain, dismissal of the indictment in exchange for immigration policy concessions. He called Mr. Bove's position, quote, fundamentally incompatible with the basic promise of equal justice under law. A quid pro quo deal, but Mr. Bove said it was fine. Even more disgracefully, he said a court cannot review at all a dismissal of this kind. This attitude toward the law alone should disqualify him, but he went further. In a March meeting, according to the whistleblower, he said essentially that lawful court orders should be obeyed. That's the nominee for a judgeship, saying that judges ought to be defied. He should not be under consideration for this lifetime appointment for these reasons and others that my colleagues who are coming to the floor tonight will describe in detail. The short-circuiting and straitjacketing of consideration of Mr. Bove will be a stain on the United States Senate. And make no mistake, we will rue the day, my colleagues will, if they vote for this nominee. And we should not in any way turn a blind eye towards the other nominees that will be before us for the district court. Josh Devine, Maria Lanahan, Jordan Pratt, all nominated to serve as trial lawyers on the federal bench. They've made careers of crusading against reproductive rights. Judge Pratt wrote an amicus brief supporting Florida's 15-week abortion ban. He called the procedure, quote, barbaric and, quote, one of the most severe invasions of personal rights imaginable, end quote. Judge Pratt went so far as to raise questions not put before the court by parties and invite the Florida Attorney General to intervene and weigh on these questions. He wrote an opinion upholding holding unconstitutional a Florida law that allows minors to seek abortions without parental consent through judicial waivers. The case didn't require a court to rule on the law's constitutionality, but Judge Pratt took it upon himself to do so, and Mr. Devine led and Ms. Lanahan worked on Missouri's legal challenge against mifepristone. The science is clear. Mifepristone is safe, yet Mr. Devine and Ms. Lanahan didn't hesitate, not at all, to challenge its approval. And their court filing cited 2 research studies mere weeks after he filed the complaint that were retracted due to a lack of scientific rigor, problematic methodology, and undisclosed bias. Edward Artown, nominated for the Southern District of Florida. The ethical lapses on his part were undeniable when he failed to recognize the obvious conflict and recuse himself from his involvement in a case involving the president at a time when he potentially was under consideration for a nomination. These nominations are unqualified. They've revealed themselves to be incapable to meet basic standards of ethical conduct, judicial independence, and if confirmed, they'd extend the administration in its reach into the courts, in effect co-signing the president's most destructive and dangerous impulses, regardless of legality. I urge my colleagues to join us in opposing these nominees. Mr. Bove should not be before this body. And I hope my colleagues will recognize the importance of standing strong and speaking out and voting against his nomination and the others that have been made. And I yield to the senior senator from Illinois, the ranking member of the Judiciary Committee, our great colleague.
Mr. President.
The senator from Illinois.
First, thank the senator from Connecticut, Senator Blumenthal, who really brings a level of expertise and experience to the Judiciary Committee and the Senate that is really unmatched. He's been a friend and a faithful participant in this process and all the time that I've been honored to serve with him, and I thank him for bringing us together this evening. Mr. President, last Friday I was in Chicago for the formal ceremonial investiture of a new federal district court judge named April Perry. April Perry has an interesting story that brought her to the bench. The story starts with her nomination to serve as U.S. Attorney for the Northern District of Illinois. That includes the city of Chicago. And she was extremely well qualified for that position and went through the Judiciary Committee at the time. I was chairing it, and went through without a hitch. She was approved and on the list of U.S. attorneys. Now, historically, U.S. attorneys were chosen by voice vote. When President Trump is in his first term in office, I believe he had around 90 U.S. attorneys spread all across the United States, and all but one, perhaps, I'm trying to make sure I'm accurate here, all but one was approved by voice vote. Now look what happens. To bring a U.S. attorney before us is a much different process today. What happened? The Democrats gave President Trump all of his U.S. attorney nominees in his first term, with perhaps one exception, by voice vote. Now it goes through an elaborate, time-consuming process. What happened? The Vice President of the United States happened. Vice President J.D. Vance of the state of Ohio decided to come to the floor during the Biden administration after we had approved 63 U.S. attorneys and to object to a voice vote. No, he said, we're going to go through the regular process. I don't like the way the Department of Justice has treated former president at the time, Donald Trump, and so we're going to insist that you dot all the I's and cross all the T's and go through the process and take several days on each one of the U.S. attorney nominees. He made that decision after 63 had been approved under Biden, and he made it when April Perry was pending. This was her chance. the Northern District of Illinois. And J.D. Vance said, no, not the ordinary process, not a voice vote. We're going to take our time. And he applied the standard not just to my U.S. attorney in Illinois, but to his own U.S. attorney in Cleveland, Ohio. He was resolute. We're going to stop the way this has been done in the past. That was literally the end of consideration of U.S. attorneys under Joe Biden. If that was his goal, J.D. Vance's goal, our vice president's goal, he achieved it. So what happened next to April Perry? A wonderfully qualified nominee ready for U.S. attorney. Well, we sat down and decided that we didn't want to waste that talent. And I went to her and said, would you consider the vacancy for the U.S. District Court that is open now? You've gone through the vetting, they've gone through the background checks, the FBI's asked all the hard questions, they've interviewed all the attorneys you worked with, and everybody finds you acceptable. Would you consider the federal bench? And she said yes, and she was approved. And we had her formal investiture this last Friday. Those are happy occasions, and there aren't many of them, I'm sure, in the federal courthouse, at least not of this caliber. And District Court Judge Virginia Kendall, who is a presiding judge over the Northern District, called together her colleagues to witness this investiture, this happy day for new judge April Perry. She brought in about 30 federal district court judges from the Northern District and a number from the 9th District or 7th District of the Appellate Court. And it dawned on me as I attended this ceremony for April Perry that this has turned out to be an important part of my Senate career. If you'd asked me when I ran for the Senate, what about the appointment of judges? I'd say, well, that's fairly routine. Turns out it's not. It's more than routine. It's one of the more important things you do, because the men and women chosen to serve in the federal court system, Article III judges, are appointed for life. For life. To remove them, you have to go through an impeachment through Congress to remove a federal court judge. That's how important it is. That's how permanent it is, the permanent nature of it. And that's why each selection makes a difference. I looked at the 30 or so judges who gathered and realized that I had had a hand in appointing every single one of them, and many others too. And so you go through that process a number of times and you learn. I look back now on all of the district court judges that I've had a hand in choosing, and I will tell you, for 2 or 3, it was a mistake. If I had it to do over again, I would have asked more questions and I would have had more information on those who were chosen. But that's over a span of 29 years, 2 or 3. Those who were approved, dozens of others, have really done well, and they've been praised for the job that they did. So when I was chairman of this committee, fortunate to have that opportunity, we approved in a 4-year period of time a record number of federal court judges, 235. President Trump in his first term had done 234. We passed him by 1 court judge. And I'm proud of that because it was a lot of hard work. We had, in order to report a judge out of the Judiciary Committee, every single Democrat had to be in their seats for every minute of the vote. There was no proxy. You had to be there. And they showed up, and Senator Blumenthal was one of those. Senator Welch has joined us now in the Judiciary Committee, and I salute them. But now, under the second term of President Trump, the rules are changing. They weren't very good the first round, and they're worse now. The first Trump administration put forward some of the most extreme judicial nominees ever considered by the Senate. Several Trump nominees had little or no experience in a courtroom, no litigation experience. Would you hire a lawyer to take your case to trial if they had never been in a trial in their lives? 3 district court nominees, Catherine Mizell, Justin Walker, and Sarah Pitlick, won unanimous support from committee Republicans despite having never tried a case. Imagine you're going in a courtroom, you're presiding over a trial. You've never seen one. You've never been in one. You may have seen something on television. You keep looking for Perry Mason and wondering what's next. That, unfortunately, was a reality with many of these nominees in Trump's first term. And many Trump nominees took some unusual, if not controversial, if not just plain wrong decisions. Lawrence Van Dyke, Ninth Circuit nominee. We asked him to affirm that he would be fair to LGBTQ individuals. He wouldn't say it, just couldn't get the words out of his mouth. Michael Turnquale, an Eastern District nominee, said of President Obama, he was, quote, an un-American imposter. Those are the words of this man seeking the federal bench about the former president. He said he would, quote, bow to Arab sheiks and other world leaders. Where did you find that nominee? The first Trump administration put forward, get this now, 10 judicial nominees who the American Bar Association found to be not qualified to serve on the federal bench. 10 of them. Well, what's the American Bar Association got to do with this? Historically, the American Bar Association did its own background check on nominees for the federal bench. Where would they go? Well, they would go in the community. They would go to the judges that this person has appeared before. They would go to the fellow attorneys. They would try to find character references, and they would dig deep. And they had some basic rules. You had to have 10 years of experience as an attorney to even be considered for the federal bench. And then they rated people qualified, not qualified, well qualified, and such. Over the strong objections of Senate Democrats, 8 of the unqualified nominees proposed by President Trump in his first term were confirmed by Senate Republicans. So even when the American Bar Association says you're unqualified to serve on the bench, it didn't discourage the loyalists supporting President Trump. Incidentally, under the Biden administration, 235 federal judges, how many of them, Durbin, give us the truth here, how many of them were found unqualified? None. Every one of the 235 were found qualified by the American Bar Association. As a former chairman of the committee said, elections have consequences, and I get it. So I understand that the second Trump administration is going to offer nominees closer to him in political philosophy. But President Trump seems intent on outdoing himself by putting forth nominees who are extreme, partisan, and fundamentally unqualified. Instead of finding more qualified judicial nominees, Attorney General Bondi ordered the Justice Department to stop cooperating with the American Bar Association in rating nominees. She didn't want to run into the embarrassment that they did in the first Trump term, with 10 of them being found unqualified. So she said the way to solve that problem is not to find a better nominee, it's to get rid of the American Bar Association. If they're not going to give a grade to these nominees, we don't have to worry about their being unqualified. She overturned a practice that had been in place for nearly 70 years, going back to a fellow named Dwight David Eisenhower. Both Republican and Democratic presidents had followed the rule. Now the only qualification that President Trump looks for in his judicial nominees, and he says as much, is loyalty. Show me loyalty or get the heck off the bench. Look no further than Emil Bove's nomination to the Third Circuit. As a senior official in the Justice Department, Mr. Bove has done nothing but cater to President Trump's every whim. It's no surprise that President Trump said he had nominated Mr. Bove because he would, quote, do anything that is necessary to make America great again. For life. Judge for life. Show me loyalty, and you got a position for life. Mr. Bove personally ordered the termination of federal prosecutors who put violent January 6 rioters in prison. Understand what happened here. Men and women, professional attorneys working for the Department of Justice, were given assignments. We have a case we want you to pursue and prosecute. It's this individual, here's the FBI background file, go to work. Turns out these people are the ones that stormed through that door and went rifled through our desk and aped for photographs sitting in your chair, Mr. President, on January 6th. As a result of their entering this building, 5 Capitol policemen died and 140 were assaulted. Should they have been prosecuted? You bet. Beat up on a cop, you should face the consequences. And they did it on January 6th in the name of stopping the election the American people had been involved in just weeks before. I was here sitting in this chair as the head of the Capitol Police stood where you're sitting, Mr. President, and told us all, stay calm, stay in your chairs, we're going to stay in this room, this is a safe room, and just stay in your seats. They grabbed the Vice President Pence, took him right out that door, and spirited him off somewhere, but they left us here. 10 minutes later, the same policeman stood up and said, new announcement, leave as quickly as possible. We cannot keep this room secure. The Senate of the United States of America, the capital of the United States of America, was being run over by demonstrators and insurrectionists. They were beating up on the police, smashing their heads into the wall and between doorlings, and they were ultimately prosecuted for it. And the prosecutors, the assistant U.S. attorneys who were doing this job, were treated in what way by President Trump when he got back in office? They were treated like they were the ones who broke the law. The prosecutors were accused of wrongdoing. Well, that unfortunately is, in the words of Mr. Bove, a grave national injustice. He thinks it is to prosecute these demonstrators. He's wrong. What was a grave injustice is what happened to the police on that day. When asked to justify his actions in firing these U.S. attorneys who prosecuted these insurrectionists, Mr. Bove claimed heavy-handed tactics by prosecutors were equally unacceptable as physical violence against law enforcement. That is an outrageous and offensive statement by a man who wants to be a federal judge for life at the second highest court in the land. Since January 7th, 2021, there's been an effort by MAGA faithful to rewrite the history of January 6th, but I witnessed it, and many others did as well. The truth is this: the United States Capitol was violently attacked by insurrectionists intent on overturning the 2020 election results. The truth is this: 5 police officers died and more than 140 were injured, protecting this building, the staff, the visitors, and members of Congress. Mr. Bove also led the Justice Department's efforts to strike a corrupt bargain with New York City Mayor Eric Adams. This is an outrage, what he did. Mr. Bove stated that the charges would be dropped against Mayor Adams without prejudice so that Adams could, quote, devote full attention and resources to illegal immigration and violent crime. In other words, President Trump needed Mayor Adams to do his bidding on his deportation policy. In response, 2 staunch conservatives resigned from the Justice Department: a Trump-appointed interim U.S. Attorney, Danielle Sassoon, and lead prosecutor, Hagen Scott. Mr. Scott wrote to Mr. Bove in, quote, a quote that will be famous for a long, long time. He said it, Senator Blumenthal repeated it, I want to say it as well. Mr. Scott wrote to Mr. Bove, who wants this lifetime appointment to the bench, and said, I expect you will eventually find someone who is enough of a fool or enough of a coward to file your motion, but it was never going to be me. I don't know Mr. Scotton, but I will tell you his words are persuasive and compelling. If that wasn't enough, Mr. Bove has shown utter disdain for our courts. A whistleblower stepped forward, gave his name, risked his future to tell us what Mr. Bove had told to the attorneys working on the case against the insurrectionists. According to this credible whistleblower who provided ample documentation to back up his claims, Mr. Bove told the Department of Justice attorneys that they might need to say, quote, F you to federal courts that issue orders this administration doesn't agree with. Mr. President, that is the most dangerous comment that a person in the position of authority can make in the executive branch, that they will ignore the court orders that are issued against them. Yesterday, the Senate confirmed Joshua Devine to the federal bench. 34 years old, received his law degree 9 years ago, litigated for 5 years, and beyond his troubling lack of experience, he's taken some extreme positions. He calls himself a zealot. He calls himself a zealot when it comes to anti-choice. This zealotry has been on full display in his role as Missouri Solicitor General. He has challenged women's ability in his state to access the abortion drug mifepristone and has undermined the decision of Missouri voters to codify abortion access in their state constitution. Also deeply troubling, Mr. Devine argued in favor of literacy tests at the ballot box, stating that people who, quote, aren't informed about issues or platforms have no business voting. Now, where does that come from? In America, literacy tests, where does that come from? It comes from the era of Jim Crow. After the Civil War, when African Americans were given citizenship and an opportunity to vote, they were intimidated in many states when they tried to. They had to answer questions. How many bubbles in a bar of soap? What do letters of marque and reprisal mean in the Constitution? Impossible questions for anyone, including the lawyers and members of Congress. And yet, off they went. Why did they do it? To discriminate against black voters. Well, it turns out Mr. Devine believes that literacy tests should be restored. It shouldn't be controversial for anyone to say that nominee has disqualified himself. The fact that the body confirmed Mr. Devine is outrageous. These nominees are just the tip of the iceberg. President Trump is going to continue to nominate extreme unqualified individuals unless the Senate takes a stand. If a few of the senators, and I'm not going to name names, who made statements about principles and values will stand by their own words when it comes to the orders of the court, then they'll join us on a bipartisan basis stopping some of these clearly unqualified individuals. I urge my colleagues, vote against Mr. Bove and all future nominees whose only loyal is to the president and not to the Constitution. I yield the floor.
Mr. President.
The senator from New Jersey.
Mr. President, I rise today to voice my strong opposition to Emil Bove nomination to the Third Circuit Court of Appeals. Mr. Bove is unqualified, unfit, and undermines public trust in our justice system. Every report makes one thing clear. He puts politics over justice, loyalty to Donald Trump above all else. We cannot give someone like that a lifetime appointment. I rise because more than 9 million people that I represent, the people of New Jersey, they fall under the jurisdiction of the Third Circuit. This nomination has a direct impact on their lives, their futures, and their rights. The people of New Jersey deserve better. They have had enough of corruption and political gamesmanship and what we see so clearly to be a system rigged for the well-connected and the well-off. Let me explain why this matters. In times when so many feel the system is working against them, courts serve as a critical check on unchecked power. Judges matter because their decisions expand or restrict basic rights. They shape the fate of immigrants seeking a better life, influence our economy, and they determine our safety and future. The courts should reflect the promise of America, a nation where the rules apply equally, no matter your wealth or connections, where fairness guides justice. Emil Bove represents the opposite. He is part of a broken system where loyalty to politics and political power trumps fairness and the law, where connections and corruption undermine justice. Mr. Bove's resume includes work as an assistant U.S. attorney, prestigious clerkships, experience in some of the world's most powerful law firms, but that is not why he was nominated. He was chosen for one singular reason, which is his unwavering loyalty to Donald Trump. And throughout his career, Mr. Bove has shown he is ethically unfit to be a public servant. He fired career prosecutors, including those working on January 6 investigations, simply because they would not follow politically motivated orders. He openly instructed subordinates to defy court rulings to continue deporting people without due process, and threatened, fired, and publicly disparaged those who refused. This is not public service. This is corruption disguised as loyalty. The pillars of our judicial system are objectively and independence. They ensure that justice is blind to politics. But Mr. Bove has shown contempt for those pillars. Over 900 former DOJ attorneys have signed a letter urging this Senate to reject his nomination, calling him unfit and unethical. The Department of Justice must stand for law, not partisan agenda. And now we're asked to trust a nominee who has proven willingly to defy the law and undermine the courts themselves. The answer must be no. And let me address a particularly troubling experience that underscores the corruption that Mr. Bove represents when he sought to dismiss the case regarding New York Mayor Adams. This is not just politics as usual. This is corruption that threatens the integrity of the very justice system Mr. Bove seeks to join. The kind of deal-making, backroom, political gamesmanship that the people of New Jersey are sick and tired of. And I say this not just as a senator, but as someone who challenged New Jersey's political status quo in federal district court and ultimately before the Third Circuit of Appeals, this very court. Approving this nomination sends a message that corruption and loyalty to power trumps qualifications and fairness. That is not the future I want for my children, my state, or this country. Mr. President, it doesn't have to be this way. That future is in the hands of this very body, the U.S. Senate. New Jersey and this country deserves better than Emil Bove. America deserves a justice system it can trust. Let us vote no on Bove's nomination to the Third Circuit Court of Appeals. And with that, I'll yield back.
President.
The senator from Vermont.
Thank you. I oppose the appointment of Emil Bove to serve on the federal court. You know, there's two issues. One for any judge is temperament. Absolutely essential, where that judge has to step back and not be partisan, has to be fair to all litigants. Emil Bove totally lacks the temperament to serve on the federal judiciary under any president, under any administration. In 2018, the federal public defender for the Southern District of New York sent a letter to the Southern District leadership detailing incredibly detailed complaints from fellow defense attorneys about Bove. These are people that work with him in a professional capacity. This was before Bove was a political figure that he's become. And they described him gratuitously as a person who was vindictive, a prosecutor version of a drunk driver, and needing adult supervision. And it was because of his conduct towards the people that he was working in the judicial system. And the reality that we all know is that in the judicial system, fierce as you may be as a prosecutor, determined as you may be as a defense attorney, impartial as you want to be as a judge, everyone has to cooperate to do their job, not interfere with others, and to be supportive of those who are doing the work with you, your fellow prosecutors, your fellow defense attorneys. And Bove couldn't do that. He does not have the temperament to serve in a high judicial position. Second, and really most importantly, Bove does not have respect for the rule of law. If you're in a litigation situation, as prosecutors are, as trial attorneys are, as public defense attorneys are, you have an obligation to serve your client fiercely, energetically. But what you have as a shared responsibility, no matter which role you have in the litigation process, the judicial process, is a respect for the rule of law and an obligation to act in accordance with the ethics that apply to you in your service. On June 24th, Perez Ravini, who was a well-respected supervisor, and this is about the Bove character, who had defended Trump policies in his first administration. This is a person who was supportive of many of the policies that the then President Trump was advocating. He came forward with a very credible whistleblower claim that Bove advocated for violating court orders. Bove reportedly said that the Department of Justice should be prepared to tell courts that whose decisions they did not like to F off. He said that, and he meant it. That's the truth. And that was gratuitous, but very reflective of the orientation that Mr. Bove has towards the law. And the law is incidental. His goals, or the goals of his now client, President Trump, are the only thing that matters. That also happened subsequently, just very recently, with the transfer of individuals to El Salvador in violation of Chief Judge Boasberg's oral order in JGG versus Trump. And that's the case where the judge gave an order stopping the deportation, and Bove was complicit in having that plane fly and actually do what was directly in conflict with the order. He also, as we know, instructed prosecutors to drop the criminal case against the New York City mayor, Mr. Adams. It was a blatant quid pro quo. Bove has been an active participant in political payback against the January 6th prosecutors and FBI agents who were simply doing their job. By the way, this is so appalling to me. You're a prosecutor. You know that if a prosecutor is assigned a case in a large office like the Southern District of New York or in the Washington District, the prosecutor's job is to prosecute that case. Well, there were a number of prosecutors who were assigned to prosecute the January 6 cases, and as you know, Mr. President, that included people who came in here and started beating up on cops. That's what they did. And those prosecutors did their job and were then fired by Bove. No loyalty to people who had the same job and the same responsibility as he did. He also, Mr. Bove, sought the names of all FBI employees who worked on investigations into January 6. You know, he stated that was part of an investigation about the weaponization of the FBI against the January 6 rioters. So he's part of the rewriting, the whitewashing of the history of January 6 that is the favored narrative of President Trump. But bottom line, Bove has made it clear that he works for his political boss, and that's the president. And the question is not just about Bove. The question is for us on the Senate, who have this real responsibility. We have our partisan differences. We have our honest policy differences. But we have a shared responsibility when it comes to the nomination of a person for a federal judicial position to evaluate their qualifications for the job. And first and foremost among the qualifications is that that individual has to be someone who sees as his or her client the Constitution of the United States and the statutory rights and obligations that citizens and companies in this country have. And what President Trump has made very clear, uncomfortable as this may be to acknowledge for many of us many of my colleagues on the Republican side who have to deal with the wrath of a president who doesn't get everything that he wants when he wants it. The reality is that President Trump himself has made it clear that the people he wants appointed, that he will appoint to the court, are people who will put him first, not the Constitution, to put his political whims, his political desires first. He's got the right person in Bove, but that's the wrong person for us to confirm. Mr. President, I yield back.
Mr. President.
The senator from Rhode Island.
Mr. President, there's a legend about a woman who finds an injured snake by the side of the path, and she picks it up to take care of it. She brings it home. She cares for it. She feeds it. She nurtures it. It heals. She takes it back to put it back into where she found it. And as she does so, it bites her. And as its venom goes through her veins and she's dying, she asks the snake, "Why did you bite me? I cared for you. I fed you. I nurtured you. I saved your life when you were wounded." And the snake said, "It's my nature. You knew that when you saved me. For many of us, to our colleagues, this is a mark my words moment about an individual who will continue to disgrace himself and the rule of law if we put him on the bench. We know that because in 6 short months at the Department of Justice, he has been involved in 3 significant instances of prosecutorial misconduct. Not little technical violations of a rule, but truly grotesque abuse of a prosecutor's powers. Not long ago, my Republican colleagues would have prevented even the nomination of a character like this, somebody with a lawless character for the bench. The mad dash to jam through this nominee, first in the Judiciary Committee and now on the floor of the United States, is a new low for the way this body handles its responsibility to vet these lifetime appointments. Let's go through the prosecutorial misconduct instances. This is a nominee who told a room full of DOJ lawyers that if the courts didn't back off on restricting unlawful deportations, they'd have to tell courts, I won't use the word on the Senate floor, F you. We know he said it. We know he said it because it is abundantly corroborated in real-time communications among the lawyers present who heard him say it. They talk about the FU comment in contemporaneous texts in that very matter. You really don't get, I'm looking at a bunch of lawyers around here, you really don't get better corroboration than that. That's the kind of corroboration that you take to the defense counsel and say, maybe we should think about pleading this case out. Why would colleagues think someone who would tell courts, F you, someone who does not believe a judge's rulings need to be followed, is fit to be a judge? We're also on solid ground concluding that this character lied to us about it in committee. He said he didn't recall. That's a heck of a memory lapse, telling a room full of Department of Justice lawyers that they should be ready to tell courts, F you. Somehow he seemed to know that he would get away with it, that he would not be forced by the majority to actually answer our questions. He also said he never instructed anyone to disobey a court order. Too cute by half. What he said was they should be prepared to violate a court order. And by the way, they did. This is all consistent with his lawless character. He also cooked up an improper deal in a criminal case against the mayor of New York, where they were going to hang a suspended criminal prosecution, well-founded and grounded, over the head of the mayor to assure his cooperation with the Trump immigration agenda in his city. You don't do that as a prosecutor. That is unimaginably bad abuse of that power. We had the corroboration in the first instance. What do we have here? We have his own DOJ colleague calling this effort a quid pro quo, calling it an improper offer of immigration enforcement assistance in exchange for a dismissal of his case. That was the deal, the arrangement that was reached. And that colleague, the acting U.S. attorney for the Southern District of New York, then resigned rather than go through with the rotten deal. Not enough corroboration? Trump's border czar, Tom Homan, admitted the scheme. He went on Fox News with Mayor Adams and said, I'm quoting here, so excuse some of the language, if he doesn't come through, I'll be back in New York City and we won't be sitting on the couch. I'll be in his office up his butt saying, where the hell is the agreement we came to? End quote. The agreement to hold back a prosecution in order to force the mayor to go along with the immigration agenda. Not enough? Okay. This nominee separately tried to confect a fake criminal investigation to allow an improper seizure of funds that Congress had appropriated, obligated, and disbursed to the Greenhouse Gas Reduction Fund. You don't invent fake prosecutions. In this case, his office said, the U.S. Attorney's Office said, there's no there there. We can't sign that pleading. He drove out the criminal chief. The rest of the lawyers also refused to sign. The U.S. Attorney went in himself, all by himself, just a political appointee, no federal prosecutorial experience, no idea what he was doing. The magistrate judge shot him down. Each one of those things is a giant red flag in the Department of Justice, and they all attach to this case. A principle that prosecutors follow is that you must not publicly disparage subjects of your investigation. It is enough that you have the law on your side and the power of prosecution to bring them to justice. You don't throw on a larding of disparagement. Bove's client in that matter, the EPA administrator, made repeated public statements accusing the fund and its administrators of being corrupt, criminal, engaging in kickbacks, theft, and graft. These accusations are defamatory per se under the common law. This person led these truly evil abuses of DOJ's powers. It is his nature. Those are the problems with the nominee. Now let's look at the problems with the process that got him here. First, in the Judiciary Committee, he was pre-licensed to refuse to answer questions. The committee, the majority, conceded something that Congress has never conceded before, that deliberative process and attorney-client privilege overcome our constitutional powers of oversight and advice and consent. Senator Kennedy and I noted this in our bipartisan report on executive privilege back in 2022. Here's our quote. Congress maintains that all other components of executive privilege, besides presidential communications, which was at issue, that the executive branch recognizes, including deliberative process and attorney-client privilege, are not constitutionally grounded and therefore cannot supervene Congress's oversight authority. To grease Bove through the committee, they threw all that history out the window. And having made that astounding concession, they then didn't even follow the rules for assertions of these supposed privileges, neither as to their scope, where they apply and don't apply, nor as to what it takes to actually claim them. These privileges need to be asserted, and the witness never actually asserted them. He probably didn't actually assert them because as a lawyer he knows they didn't actually pertain, and he would have been mocked and criticized for asserting those privileges in this circumstance. He knew from the free pass he'd been given not to answer questions that he didn't have to answer, and he didn't have to make the assertions. With his non-answers blessed in advance, he hid behind vague claims of inappropriateness. That is not a privilege. That is not a defense. Attorney-client privilege and deliberative process privilege, even if they pertained here, don't apply to administrative decisions within a department, and deliberative process, indeed any executive privilege, does not apply where the allegation is misconduct. We just went through the 3 instances of prosecutorial misconduct. Again, from my report with Senator Kennedy, quoting the D.C. Circuit here, the privilege disappears altogether when there is any reason to believe government misconduct occurred. The only executive privilege that Congress does recognize also requires proximity to the president. It is not applicable in ordinary agency administration, and the president must invoke it, and he didn't. The Attorney General and the Deputy Attorney General even showed up at the hearing to give committee Republicans the eyeball. The result was a hearing that more resembled a rackets hearing from The Godfather than a nominations hearing for a Circuit Court of Appeals judgeship. One last point. While this mischief is going on in the Judicial Committee and on the Senate floor, something else is going on. This is a two-ring circus, and the second ring is over at the D.C. Circuit Court of Appeals, where Trump judges Rayo and Katsas, over objection, stopped the court hearing into Bove's potential contempt in the deportation cases. Obviously there, in court under oath, real answers would be achieved. The administrative stay procedure those Trump judges used usually only lasts days. Justice Barrett recently chided a court for an administrative stay that lasted 2 weeks. These two Trump judges have blocked Bove's contempt hearing for 3 months. If my colleagues keep rubber stamping Trump's lawless nominees, he will just continue lowering the bar, further degrading the judicial system. This has the earmarks of a coordinated play, and I suspect very much that we have not heard the end of this as facts continue to come out in future Judiciary Committee investigations and in the contempt hearing of Judge Boasberg. I yield the floor.
Mr. President.
The senator from Hawaii.
Mr. President, we have an administration that is flouting the law at every turn. Since being sworn into office, Donald Trump has signed dozens of executive orders attempting to do everything from ending birthright citizenship and eliminating the Department of Education to invoking the Alien Enemies Act to deport individuals without due process. In the months since, lawyers defending these lawless actions in court have been rebuffed time and again by judges across the country, including judges nominated by Donald Trump himself. Note that even Donald Trump's nominated judges have said, you can't keep making these kinds of arguments before me. So now Trump has gone even further by nominating to a lifetime judgeship a man who makes no secret of his disregard for our courts and the rule of law, and that man is Emil Bove. Based on his nomination hearing and a review of his background and the record before us, Mr. Bove is unfit to be a federal judge because of his disregard for the rule of law and his temperament. There are so many red flags regarding this nominee as articulated by my colleagues before me. Mr. Bove has no respect for the rule of law or the courts that uphold it. This was made all too clear by a whistleblower, a man who had the courage to point out certain things about this nominee, and this courageous whistleblower is Erez Riveni. Mr. Riveni was a career attorney at the DOJ before he was fired by the Trump administration for admitting, by not lying to the court, that the administration made a mistake in deporting Kilmar Abrego Garcia to El Salvador. Note this. He was fired because he told the truth to the courts. He was expected to lie to the court and say, oh, the Trump administration did not make a mistake in Mr. Garcia's case. The facts prove otherwise. Far from being a rogue partisan, Mr. Riveni spent 15 years at the Department of Justice, including during the first Trump administration, where he received awards for his work defending the administration's policies in court. Mr. Riveni shared with the Judiciary Committee that Mr. Bove, the nominee before us, casually discussed ignoring court orders at a meeting attended by not just Mr. Riveni, but by a bunch of other AGs in the Department of Justice. So while Mr. Bove and my Republican colleagues would like us to focus on whether Mr. Bove actually directed the government to ignore a court order at this fateful meeting, that hope misses the point. According to Mr. Ravenni, Mr. Bove said the Justice Department would, quote, need to consider telling the courts, F you, end quote. If the court ordered the administration, the Justice Department, to stop what they were doing. Neither Mr. Bove nor anyone else has denied the sequence of events. Mr. Ravenni produced 100 pages of documents and text messages supporting his statement that under Bove, DOJ lawyers were directed to prioritize the president's political agenda over their legal and ethical obligations. My Democratic colleagues and I tried to ask Mr. Bove about these revelations, but unsurprisingly, he refused to answer nearly all of the questions on these points. And as noted, he even cited two privileges that don't even apply to him. So we didn't get much in the way of responses from Mr. Bove. So as for the committee, rather than hold a hearing to hear from this whistleblower under oath, Republicans on the Judiciary Committee chose to rush through Mr. Bove's nomination, breaking precedent by refusing to allow Democrats to even speak on his nomination in committee. I'm sure people saw that the Democrats on that committee walked up in protest. Beyond his disregard for the rule of law, Mr. Bove also lacks the temperament to be a federal judge. You know, we expect our federal judges to be fair, to be objective. We don't expect them to have political access to grind. But that is not what we're going to get with Mr. Bove. One issue that is particularly important to me is harassment and abuse of law clerks and court staff by federal judges. Those with nearly absolute power, like a federal judge in their chambers, can do great harm to those that work for them. That is why I introduced a bipartisan, bicameral bill aimed at addressing workplace harassment in the federal judiciary. We know this happens. So this issue arises with regard to Mr. Bove because of reports that he was an abusive supervisor at the Southern District of New York. In other words, he is a supervisor who abuses his powers. When questioned, Mr. Bove confirmed that a group of office leaders recommended to the U.S. Attorney that he be removed as a supervisor of the unit that he was leading. According to reports, this came after an investigation, and Mr. Bove only kept his job after he pleaded to keep it. It is frankly astounding that these very busy prosecutors in the office that he was in considered Mr. Bove's behavior so concerning that they went so far as to investigate his behavior and recommend his removal. And to clarify things, I asked Mr. Bove in questions for the record to send us copies of his personnel file. He refused. Far from an independent, fair-minded jurist, Mr. Bove is willing to use whatever means he deems necessary to meet the ends sought by Donald Trump. There is absolutely no question that the reason Mr. Bove came to President Trump's attention was his complete loyalty to President Trump, which he manifests clearly. You know, this is a concern. Don't take my word for it. I want to show you, Mr. President, this is a letter signed by nearly 1,000 former DOJ lawyers urging this body to reject Mr. Bove's nomination. They wrote, quote, "We, the undersigned, proudly defended the rule of law as attorneys at the U.S. Department of Justice. We are all alarmed by DOJ leadership's recent deviations from constitutional principles and institutional guardrails. These almost 1,000 letter writers continue, quote, Emil Bove has been a leader in this assault. Despite that, he now stands before you as a nominee for a lifetime seat on the U.S. Court of Appeals for the Third Circuit. It is intolerable to us that anyone who disgraces the Justice Department will be promoted to one of the highest courts in the land, as it should be intolerable to anyone committed to maintaining our ordered system of justice. They went on to remind us that each of us in this body was elected by a democratic process anchored by the rule of law, and urged us to protect the rule of law by voting our conscience and rejecting Mr. Bove's nomination. Mr. President, I ask unanimous consent that the letter I referred to be included in the record.
Without objection.
For all the reasons provided by me and my colleagues before me on the Democratic side, I urge my colleagues to join me in defending the rule of law, not putting into a lifetime appointment somebody who thinks that he can ignore court orders, and certainly not by saying F you to the courts, that person not be confirmed by this body. We need to do our jobs by rejecting this nominee. Mr. President, I yield.
Mr. President.
The senator from California.
Mr. President, the Senate this week is considering a nominee so patently unfit to be a federal judge, so lacking in the temperament, integrity, and judgment to serve as an arbiter of the nation's laws, that the chorus of opposition has grown deafening, and the facts revealing his unfitness for office are too voluminous to be ignored. I'm speaking, of course, of Emil Bove, the lawyer whose misconduct was so egregious that his fellow prosecutors in the Southern District of New York thought he should be demoted. Someone whose management of cases was so flawed that a federal judge not only concluded that his team had misled the court, but that it withheld exculpatory evidence. And the court then ordered the case dismissed. And the Southern District Prosecutor's Office didn't even bother to try to refile the case. It was that tainted by Mr. Bove's leadership of that team. After Bove left the U.S. Attorney's Office under the threat of demotion, he became one of Donald Trump's criminal defense lawyers, losing the hush money payment to a porn star case in which Donald Trump was convicted of dozens of felonies. Bove, though, turned that loss and his blind obedience to Trump into a top position at the Department of Justice. And now for the past 6 months, it seems like every time there's been an abuse of power at the Justice Department, Emil Bove either directed it, supervised it, or carried it out himself. When Donald Trump wanted to purge the Justice Department of prosecutors who worked diligently to investigate the January 6th insurrection, Bove was the instrument of his vengeance. When Trump wanted to purge the Department of Prosecutors who proved to juries beyond a reasonable doubt that the violent offenders who attacked police officers that day did so to interfere with the peaceful transfer of power, Emil Bove was there to punish not the criminals, but the prosecutors. When Stephen Miller and then FBI Director Kash Patel worked to carry out an additional purge of career FBI officials who worked on the January 6th investigations, Emil Bove was there too. Earlier this year, when the Trump administration wanted a justification to freeze grants already approved from the Greenhouse Gas Reduction Fund, and they wanted to trump up some justification, some rationale for trying to prevent the distribution of these funds. Who did they turn to? Well, of course, they turned to Emil Bove. He and then U.S. Attorney Ed Martin pressured the head of the criminal division for the D.C. U.S. Attorney's Office to open a criminal investigation into the fund. But there was a problem. There was no evidence of criminal activity. There was no probable cause. There was no predication. And how do we know this? How do we know the opening of this case or the threat of opening this case was bogus? Because the chief of the criminal division in that office resigned rather than comply with this unethical edict. When Trump's DOJ sought to dismiss a serious and credible corruption case against the mayor of New York, Eric Adams, who was the one who ordered career prosecutors to drop the case? That's right, Emil Bove. Time after time, we have seen career public servants stand up to abuses of power like this and refuse to obey, leaving careers they loved at the Justice Department, rather than be part of Bove's perversion of justice. I served for almost 6 years in the Justice Department. I know the sense of mission that the lawyers in that department feel and how much they love serving and appearing before a court and introducing themselves as on behalf of the United States. It is not a job that people give up easily or for no reason. But I also know that when put in the position of choosing to follow their ethics and the law, choosing to obey a dishonorable and dishonest instruction from a supervisor, yes, they will resign their post, and so many have. Acting U.S. Attorney Danielle Sassoon was ordered by Bove to dismiss the indictment against Eric Adams. In refusing, she called it what it was: an improper offer of immigration enforcement assistance in exchange for the dismissal of his case. In other words, a quid pro quo. Now, I just want to underscore for people what this means and how astonishingly abnormal, unethical this action was. The Justice Department intervened in a criminal case in New York over the objection of the prosecutors handling the case, including the acting U.S. attorney, to dismiss that corruption case against a public official, not because there was a lack of evidence. They didn't even try to claim that. Not because there was any prosecutorial misconduct. They didn't even try to argue that. But because he was useful to the president on his immigration policy. It is an edict from Bove that says, if you do the president's bidding, we've got your back. We'll make your corruption case go away. Quid pro quo. Now, interestingly, they didn't want it to go away completely. They wanted it to go away without prejudice. That is, so they could bring it back if he didn't do exactly what the president wanted. Anyone who's ever served in the Justice Department could tell you just how unethical that is. And rather than obey those orders from Bove, the acting U.S. attorney, Sassoon, resigned, and many others followed. One of them said, quote, "I expect you will eventually find someone who is enough of a fool or a coward to file your motion. But it was never going to be me." No, it didn't have to be him because it was Eric. It was enough for Emil Bove. He is there whenever Donald Trump needs someone to carry out his will, regardless of ethical or even legal considerations. And dedicated public servants, career prosecutors are standing up to him, willing to risk their jobs, willing to risk retaliation by a vindictive president. Some of those brave attorneys have come to our committee as whistleblowers. In one case, Erev Raveni, a 15-year veteran at the department who worked in both Republican and Democratic administrations, shared with our committee that Emil Bove told DOJ lawyers that they would need to consider telling the courts F you, and ignore any such court order that might get in the way of the Trump administration's strategy of rapid deportation without due process. And in fact, Bove's lawyers at DOJ would go on to lie to the judge and violate court orders, prompting the judge to issue an order to show cause why they should not be held in contempt. And Senator Whitehouse is exactly right. The Court of Appeals has delayed that hearing on the order to show cause why those lawyers under Bove's supervision should not be held in contempt. And my colleagues here want to rush this thing through. Well, what will they say if the judge finds that Bove and others at the Justice Department willfully ignored court orders? What will they say once they've given him a lifetime tenure on the Court of Appeals? Now, during Bove's confirmation hearing, I asked him about his FU instruction, and he made the dubious claim that he couldn't recall. Now, that's remarkable. It's not like we're talking about events that happened 10 years ago. This was like 2 months ago, just a few weeks ago. I think I would remember if I had told other lawyers that we should say FU to the courts. So either he instructs them frequently to say FU to the courts, such that he wouldn't remember this particular occasion, or he's being dishonest with us. But his use of that vulgar injunction was corroborated by other DOJ lawyers in text messages, so we really don't need to wonder about this. As one DOJ lawyer texted another, "Guess it's find out time on the FU." Well, now it's find out time for the U.S. Senate, where we find out whether we are willing to confirm just anybody, no matter how unfit, no matter how terrible the record, no matter how abundant the evidence. It is find out time for the U.S. Senate. Now, what was Bove's role in tasking DOJ and FBI to scour old Epstein files and flag mentions of Donald Trump? I know my colleague, Senator Booker, has tried to find out, and Senator Durbin has tried to find out. We don't know because Bove refuses to tell us. But we do know that his fellow criminal defense lawyer, Todd Blanche, he and Blanche were the two lawyers that represented Trump in that hush money payment to a porn star case, that Todd Blanche is now rushing to meet with Epstein's chief co-conspirator in jail. It is self-evident that Blanche is there to represent the president's personal interests, not the public interest. And Bove represents exactly the same problem. With Bove's nomination, we are about to find out if Republicans are content to give a man so routinely in defiance of the rule of law a lifetime job interpreting it on behalf of millions of Americans. We wanted to hear from those whistleblowers like Erev Ravani, just some of the hundreds of public servants who are speaking out, but Republicans declined our request for testimony and additional hearings even as they rushed to jam through this nomination for a lifetime position. And sadly, we will all have a lifetime to regret it. Like so many of his unfit cabinet nominees, Donald Trump is daring Senate Republicans to oppose him. I hope and pray they will, because the pattern is clear. Emil Bove takes orders from Donald Trump, and that is it. His only merit is blind obedience, not to the law, but to the president. And not just any president, but to one who is also a convicted felon. And so I urge my colleagues, look at Bove's record of disrespect for the law and reject this dangerous nominee. Mr. President, I yield back.
President. The senator from New Jersey.
I really appreciate that recognition, sir. I've seen something I haven't seen since I've been on the Judiciary Committee, which is a complete chorus of condemnation of a circuit court judge. We've had every single person express an interest in coming down here from the Democratic members of that committee to condemn us moving forward with such rapid pace on this nomination. Now, I would love to just leave it there, but there is something that makes it even more urgently necessary to focus, because as much as it might seem like this is a Democrat versus Republican, I'm very happy to see already some Republicans, not enough for us to stop this nomination, but this will be a bipartisan group of opponents, which is rare in this time of fierce partisanship, to see some Republicans looking at the evidence, looking at what Mr. Bove has said, looking at what Mr. Bove has done, looking at how he has insulted the very office that he hopes to hold of a judge's orders. People who are looking objectively at the facts are starting to see that this would be a terrible mistake in a bipartisan way. That gives me some hope that with the hours left on the clock, perhaps others too will take the time to understand one of two things. One, clearly, as I believe, and others, not just Democrats, but career prosecutors, career public defenders. We have seen judges. We have seen so many people come forward from both sides of the aisle to say, this is wrong. It would be wrong for the senators to do this. This is why we're starting to see some Republicans show more interest, and at least more than one come forward and say they will not support this nominee. It's because the facts are so glaringly clear that this is someone who has no respect for the rule of law. This is someone who's shown that no temperament to be a judge. This is someone who has been condemned for his lack of ethics, that has withheld exculpatory evidence as a prosecutor, has been given the worst Brady violation condemnation from a judge. There are so many things that are legion about this individual that on the face of it is why so many career professionals are coming forward to say that we should not be moving forward. But the second reason why people are having pause is because we are rushing this nomination before questions are answered. Too many people are moving too quickly on the other side of the aisle to get this done before questions are answered. Information is obtained from the record that this body, which is supposed to be deliberative, is supposed to advise and consent, should not be moving forward if they were to honor the obligations that we have. Let me give the multiple reasons why we are moving too quickly without information on substantive things that should raise alarms for all of my colleagues. We asked to hear the testimony of a whistleblower who came forward with tangible evidence, texts, and emails showing that Emil Bove instructed the DOJ attorneys to ignore a court order if it impeded Trump's agenda. Bove said, "F you to the courts." Republicans and the Senate Judiciary Committee refused to hold a hearing to meet with this whistleblower, not a Democrat, but a career prosecutor. Instead, we saw the vote being rammed through in the committee. Senator Kim and Senator Blumenthal and members on the Homeland Security and Governmental Affairs Committee, which has oversight on the question of whether DHS violated a court order, asked the whistleblower to testify before them under oath. That committee has also not concluded their oversight. It is just a stunning and alarming fact that my colleagues on the Republican side have disregarded the credible account of someone who dedicated 15 years to public service and jeopardized their career and reputation to come forward at a time that people who step forward and tell the truth often face real reprisals. Second, in 2018, many former Southern District of New York prosecutors took the unprecedented step of alerting Emil Bove's supervisors to his unethical conduct as a prosecutor, calling him the drunk driver of prosecutors, saying that he was reckless and dangerous in the way that he went about with prosecutions. Unprecedented step of former SDNY prosecutors. 2 years later, Emil Bove was responsible for the biggest Brady violation in Southern District of New York's history. He withheld exculpatory evidence, resulting in the DOJ having to toss out the case after a guilty verdict. His actions were so egregious that the judge used them as an example of what a prosecutor should never do. Many of my colleagues and I on the Judiciary Committee have requested more information from the Southern District of New York about his tenure. We still have not gotten it, yet we are moving forward. Number 3. Finally, after receiving credible information of Emil Bove's role in the Trump administration's burying of evidence about what is going on right now, the man that was at the central position to know what was going on with the Epstein files, we have made legitimate requests from him about this, and he has not responded. There are so many questions about Mr. Trump's interest in hiding whatever their files are, contradicting themselves. Either there are truckloads of evidence and lists, or they're not, but Emil Bove was acting in the Justice Department at the time, and now we have even more reason to question Emil Bove. Just hours ago, it was revealed that the DOJ told Donald Trump that his name appears many times in those files. Emil Bove was the top official at DOJ who also happens to be Trump's personal lawyer. We should know what his role was in reversing course on releasing those files. It would be unconscionable for the Senate to move forward with his confirmation with those answers not being provided. As I told the Judiciary Committee, there is a false urgency around this nominee. The only reason for this urgency is because the president wants his loyalists on the federal bench without facing any more scrutiny as to what he knows and what his role was. Even without answering these questions, there is more than enough in his record that disqualifies Bove from a lifetime appointment to one of the highest courts. But let's go one more, January 6th. Bove's role in Donald Trump's administration's effort to erase the tragic events of January 6th, of that attack on the Capitol, is disqualifying. As one of his first official acts, Trump pardoned nearly 1,600 people who attacked this Capitol, including 200 people who violently assaulted the law enforcement officers. Bove was one of the highest-ranking officials at the DOJ, and he said under oath that he advised the president on these pardons, and then he turned from freeing dangerous people convicted for assaulting police officers from prison to punishing the dedicated law enforcement agents who investigated those cases. Bove wrote a memo saying that prosecuting those who attacked the Capitol was, quote, a grave national injustice. So he went after those prosecutors. He fired those federal prosecutors and FBI agents who worked on the January 6th investigations. Bove then demanded a list of every single FBI employee who touched one of those cases, and in doing so, he exposed thousands of law enforcement officials to potential retribution by the pardoned and dangerous January 6th offenders. They're now roaming free. Several of these prosecutors reached out to my Republican colleagues and wanted to share their concerns, but not one person agreed to meet with them. The president can nominate judges to the court, but, and this is critical, he can only do so by with the advice and consent of the Senate. This is a constitutional duty imposed on this House, and it requires us, every single senator, to fully and fairly consider every nominee. Willful ignorance does not excuse any of us from our responsibility to seek the truth. It does not excuse us from our constitutional duty to provide advice and consent. I plead with my colleagues, look at the facts, give it your scrutiny, analyze this nominee, look at his record. Emil Bove has shown time and time again his disrespect for the very office he seeks to hold. For God's sake, we have a whistleblower who brought testimony, receipts, texts, and emails showing that Bove said, despite the fact that he denied it in our hearings, said F you to court orders. He withheld evidence that could have helped to release an innocent person or a defendant. He broke his code of conduct. He broke his ethics. He advised for pardons on January 6th and then fired the dedicated law enforcement agents who investigated and prosecuted violent insurrectionists. And now he has critical information regarding the Epstein files. There's a lot of pressure these days to hastily push a person through who cannot be trusted on the federal bench. There's a lot of pressure these days to rubber stamp nominees. There's a lot of pressure these days to look the other way, even though the evidence is clear. There's a lot of pressure these days, but some of my Republican colleagues have broken and are standing, despite the pressure, are saying this person does not belong on the bench. I am grateful that some of my Republican colleagues are standing up and doing the right thing. There is a lot of pressure these days. There are a lot of threats. The president has put enormous pressure on people in the Republican Party who stand up and do the right thing. And yet, I've seen profiles in courage. In the first Trump administration, I saw them numerous times. I could tell you their names, from Corker to Flake. I saw my colleagues who, in times of great distress, stood up when we had a trial here. Multiple people said the president was guilty, who voted against judges that were not fit for the highest office in the land, who voted against nominees for his administration. I've seen this time and time again, the courage of Republicans in times of distress. I don't know of another case I have seen in my 14 years in the Senate where someone so unqualified for the bench is before us, but somehow right now it just seems to be too few Republicans willing to stand up with courage of their convictions, to call it like it is, to do their constitutional duty, to look squarely at the qualifications of this judge and see what plainly professionals, prosecutors, judges by the hundreds from both parties have come forward and said to this body, do not let him to go forward. There are just hours left before our final vote on this nominee. This is a time for another profile in courage. I'm hoping my Republican colleagues will look at the evidence and join with a conclusion held by so many patriots in our country and not let this man to the highest court, to one of our highest courts in the land. Thank you, Mr. President.
Chair recognizes the senator from Connecticut.
Thank you, Mr. President. As we close this colloquy, I want to thank my colleagues who have come to the floor, Senators Durbin, Kim, Welsh, Whitehouse, Hirono, Schiff, and now my great friend and colleague, Senator Booker. And to my Republican friends, let me just say, there's ample evidence on the record already to say no to this nominee. But even if you disagree, what is undeniable here is the point that Senator Booker just made and that I made at the very beginning. This record is incomplete. The questions are unanswered. And just today, I have written to Attorney General Bondi about the report and investigation that was done by the Office of Professional Responsibility. We've had no access to it. It was done because of a conclusion by the court in a case before it between 2019 and 2021 in the Nijad case that criticized Mr. Bove for offering little in the way of supervision when material was denied to the defendant, and the case had to be dismissed. The extent and scope of that investigation has never been disclosed. That's just one example of material that we have a right to see that raises questions that we should insist on being answered. That letter almost certainly will never get a response, certainly not in time for our vote. But my Republican colleagues will be haunted by those questions. They will be compelled to answer those questions one day to their conscience, because this nominee is different. This nominee should be rejected. Thank you, Mr. President. I yield the floor.